webinar for those who are not able to attend today's celebrations. So again, thank you for joining Independent Living Nova Scotia and Empower, the Disability Resource Center, for our third webinar, which is called How the Human Rights and Occupational Health and Safety Acts Ensure an Inclusive and Safe Workplace. Today we have Andrea MacNevin, who is the owner of MacNevin Law Mediation. She combines more than 10 years of mediation, facilitation, and negotiation skills with nearly 5 years of work in labor and employment law and labor relations to provide a resolution-focused approach to the client's workplace issues. Today, Andrea is talking about employers and employees' rights and obligations in accommodating disability in the workplace, and how Nova Scotia's occupational health and safety legislation helps employees get back to work safely. So without further ado, I am passing it over to Andrea.
Thank you, Caitlin, and welcome everyone. I think people are still pouring in, and that's just great. I would like to begin by acknowledging that I am broadcasting today from Mi'kmaq, the ancestral and unceded territory of the Mi'kmaq people. This territory is covered by the treaties of peace and friendship, which the Mi'kmaq and Wolastoqiyik signed with the British Crown in 1725. The treaties did not deal with the surrender of the lands and resources, but in fact recognized Mi'kmaq and Wolastoqiyik title and established the rules for what was to be an ongoing relationship between nations. And honoring this treaty relationship through a land acknowledgement is just one of the many steps that can be taken towards reconciliation, as outlined in the 94 calls to action issued by the Truth and Reconciliation Commission of Canada in 2015. Actually, 5 years ago yesterday was when the TRC calls to action were released, and the Missing and Murdered Women and Indigenous Girls and Women Inquiry Report was issued 1 year ago today. So it's very relevant to think of these important documents that we now have to understand our ongoing relationship with our Indigenous peoples. And it's important, or it's impossible rather, to invoke the TRC calls to action without also recognizing that it is the colonial systems which have created the need for reconciliation in the first place, and that these same systems have also oppressed and irreparably damaged our African Nova Scotian communities, and that these systems that oppress are counterbalanced in their disproportionate distribution of privilege and power to Caucasians. And as a Caucasian person, it's difficult myself to reconcile my role in this history, or my history in this role. And I grapple with this on a very personal level, and I think that we all should. Every individual and every institution has a role to play in making the needed changes, and I think one action that anyone can take is raising cultural awareness and figuring out how to be anti-racist, learning about other cultures, asking questions, reading, and becoming more self-aware. It seems simple enough, but you have to go into that process being prepared to be humbled at any point, because you're entering a lifelong learning journey and you'll make mistakes. I expect that I will learn from my audience here today through your comments and questions, and I look forward to those at the end. Being a non-disabled person, I recognize that there is a lot I don't know, but I've tried to prepare an informative presentation for you today, and I thank you in advance for your participation. So I will be talking today about the Occupational Health and Safety Act and the Nova Scotia Human Rights Act. And the Nova Scotia Human Rights Act has provisions that are very similar to human rights acts across Canada. So I'll also be talking generally about how human rights acts operate within the workplace to ensure prevention of discrimination and equality within the workplace. So what comes from the Human Rights Acts are that employers in Canada generally have a duty to accommodate employees with protected characteristics within the workplace in order to prevent discrimination and to ensure equality. And this includes the protected characteristic of disability, of course. And this comes from, in Nova Scotia, Section 5(1) of the Nova Scotia Human Rights Act, that no person shall, in respect of employment, discriminate against an individual or class of individuals on account of, and there is in this slide, the full list of enumerated protected characteristics. And within that, you see physical disability or mental disability. And the way that disability has been interpreted by the Human Rights Act is to be a perceived disability or a real disability. And that's been interpreted to either be the perception of a disability that doesn't exist, that results in discrimination to the worker, or it can be a diagnosis that doesn't actually create any functional disability, doesn't actually create any functional restriction on the worker to perform the tasks, and yet they are still discriminated against based on a diagnosis that has a name that can be named. So very basically, an employer will have the duty to accommodate, or their duty to accommodate will be triggered when any of the characteristics listed within the Nova Scotia Human Rights Act present themselves in the workplace. And as mentioned previously, this definition of what constitutes a disability doesn't necessarily coincide with what other institutions may describe as disability, but it's very broad. A broken bone can constitute a disability for the purpose of the Human Rights Act if it results in somebody being unfairly disadvantaged or discriminated against in the workplace. So with respect to our current situation with the global pandemic and COVID-19, as we go back to work and for workers who have continued to remain in the workplace, it's important to understand that, COVID-19 can result in the duty to accommodate being triggered. So any employee who develops symptoms of COVID-19, or an employee who has reason to believe they may have encountered someone who was infected with COVID-19, or an employee who is immunocompromised, may all be situations where an employer has a duty to accommodate. So the question is, when will there be discrimination? And there will be discrimination when a complainant can make out a case for discrimination on a prima facie case basis. And prima facie is a fancy Latin word that just means on its face. So in other words, in the absence of any defense, the complainant would have established discrimination. There's three components to a prima facie case. The first component is that the complainant has a characteristic that is protected under the Human Rights Act. And the second component is that the complainant was denied an accommodation or was treated differently in the workplace in a manner that created a negative impact on them. And the third component is that the protected characteristic was a factor in the denial of the accommodation or in the negative treatment. So it doesn't need to be the only reason or the most majority reason for why that negative treatment occurred. It just needs to be a factor. So I put a little example together here. It's very basic. So a delivery driver left work to have a foot amputated, and after completing recovery, the employee's doctor provided a letter stating that the worker was fit to return to work without any restrictions, and the employer refused to take the employee back to work. In that example, that particular employee would have made out a prima facie case of discrimination without anything more from the employer, and then the employer would then be put in the position to defend a human rights claim. And the most important thing for an employer to remember when they are faced with a human rights complaint or potential discrimination a claim of potential discrimination in the workplace, is that the analysis into whether or not an accommodation is appropriate or whether or not there's been discrimination needs to be done on an individualized case-by-case basis. And this is, you know, if people are only, if you're an employer who's tuned in and watching this, and if you're only taking away, you know, 30% of what is said, then I think this component of what I'm saying needs to be included in that 30%, that you can't batch analyze human rights. It needs to be done case by case. So before we get into this slide, which talks about a bona fide occupational requirement, the employer could bring evidence to show that to refute the employee's claim that there was a prima facie case of discrimination. So one way that could be done, for example, would be to show, in the case of our delivery driver who had their foot amputated and was not taken back to work, one way would be to show that, for example, you know, it's a global pandemic and we've had to lay a lot of people off, and you would have been laid off anyway, and we don't have a job for you. So there's no longer that that third component can't be made out, because the reason why the employer is not bringing the person back to work is not actually related. That would be the employer's argument that it's not actually related to the amputation. It's related to the layoffs that needed to occur. The other primary defense that employers have to make out, and where the duty to accommodate comes from, is in this bona fide occupational requirement analysis. So an employer may argue that the rule or standard or practice that's adversely affecting or discriminating against the employee is a requirement for the job. And so again, there is a three-part test that an employer has to meet in order to make out in order to establish that they have a bona fide occupational requirement. In the first place, they have to show that the practice was adopted for a purpose related to job performance. The employer believed the practice was necessary to fulfill the work-related purpose, and that the practice is reasonably necessary in that it would be impossible to accommodate an employee with the complainant's characteristics without imposing undue hardship on the employer. So we're going to get into that term, undue hardship. So undue, by Webster's or any ordinary dictionary, would be excessive or inappropriate amount of hardship. The fact that the term within this particular legal test is undue implies that some hardship is expected. So this is the Supreme Court of Canada and other case law across Canada has kind of come up with a list, a non-exhaustive list. So this is not a complete list of anything that could be used to establish undue hardship, but it's where someone might start to look to say, I can't provide an accommodation to this employee for any number of reasons. So this is just a list that could be a starting place, for example, but once again, this needs to be done on an individualized basis. So it needs to be looked at in all the components of the particular circumstances of a single case. So financial cost, if the cost of accommodating a person would be prohibitive for the employer. We just heard from the previous presenter that typically accommodations in Canada cost an employer approximately $100. So it's unlikely that cost alone would be the factor. There may be other situations, for example, where an employer is already accommodating a number of employees and realize that they are not able to, or they would reach a point of undue hardship by accommodating, maybe there's a threshold where, they've just reached, they wouldn't be able to accommodate anymore if, for example, they're having to change shifts or not having people work on a night shift, for example, if that's part of what causes the company to be productive. It's possible. Again, it has to be done on an individualized basis. The interchangeability of the workforce and facilities, so that's looking at whether a worker could be switched between positions or switched between facilities. The size of the organization, typically a larger company will have an easier time with any of these components, but not necessarily. That there might be more opportunities for modified work or bundling together jobs to make work that an employee can do. Disruption of a collective agreement. So that is, shift scheduling is an example here as well. So if within a collective agreement, there's scheduled shifts that employees are mandated to work, and for example, looking outside of disability, but if somebody had a religious belief that required them not to work on a Sabbath and the collective agreement required working on that day, then the employer could look at, and they'd need to work with the union to look at what options were available to provide that worker with the shift that accommodated for that religious belief. And again, this would need to be, the disruption to the collective agreement would need to be more than just changing those shifts. That wouldn't be undue hardship to have to change the shifts. It would need to be, perhaps interrupting seniority, or if there would need to be other workers' rights engaged that would then need to be balanced against the right of the person who requires the accommodation. And to understand, then you would be going into a balancing of rights analysis. Outside sources of funding, that again goes towards financial cost. If the employer is able to find funding, grants perhaps to fund specific types of accommodations within the workplace, or to create, even perhaps to create a position that would allow the worker to maintain their position. Employee morale problems. Again, this would not be, it doesn't, if other employees are complaining that somebody's being accommodated for, and the shift, maybe they've been given a shift schedule that seems desirable, and they complain about that, that's not what's being considered here in employee morale problems. There needs to be a true interference with the rights of other employees, not just bickering amongst themselves and, potentially further discriminating against someone or bullying within the workplace, which the employer couldn't use the Human Rights Act to prop up that behavior. If there's a safety risk, I know of an example where a worker wanted to come to work with using medical cannabis, and he had a job that was highly safety sensitive, and it went all the way to arbitration, and it's still being appealed, this particular case. But the law at this point found that the employer would be put in a position of undue hardship to have an employee in such a highly safety sensitive workplace consuming a substance that could potentially impair him to do the work that he was required to do. And I think part of the consideration in that case was that it wasn't his risk alone. Other employees were also bearing the risk of him conducting work that was highly safety sensitive. The overall economic climate, the COVID-19 pandemic is a great example of this. If there's an economic downturn, it may affect the employer's ability to offer an accommodation that they would have been in a position to offer in different economic times. And accommodation measures previously taken, an example of this is where substance abuse issues are involved. So if somebody, typically an employer in the case of substance abuse issues, would be required to offer multiple opportunities for that person to get into recovery. And that's based on understanding the nature of how addiction issues work and working with them to bring them back into the workplace in a way that works with how we know recovery can work, and relapses, and trying not to punish employees for having addiction issues in the first place. So that's one example of that. There are others. And I appreciate that questions may be arising, and I will leave time at the end to go through all of those. With respect to coming up with an accommodation, one thing that an employer will often ask for is a doctor's note, and the information that's being required is to help the employer understand what restrictions the employee has or will have in performing the job. And so they don't need to know every single thing about the employee's health information. They really just need to know the particular restrictions or limitations that that employee will have in performing the job. And that's why those doctor's notes are asked for. We do know that during the COVID-19 pandemic, employers have been asked not to request doctor's notes. The Canadian Medical Association has requested, and the governments have responded by suggesting that employers not ask for doctor's notes when it has to do with coronavirus or COVID-19. So following an employee's quarantine or period of infection, they are not allowed to request a doctor's note to prove fitness to return to work. So there are other methods that employers should take to ensure that employees are fit to return to work, like screening questionnaires that they sign off on. Some employers can implement, depending on the type of work or how the workplace is structured, temperature screening. And all of these things, of course, need to be done in a way that protects the privacy of workers and their confidentiality of their health information. This is going over some of the things I just spoke about, so I'll just carry on. So once the employer has their duty to accommodate being triggered, they've met with the employee to understand what the issue is, they've requested further information from the doctor, and now they have that information. Now they have to look at what can be done, what accommodation, if any, is possible in the situation. And this is just, these 4 questions are just a kind of sort of simple way to start that analysis. So can the employee perform the job existing as it currently is? If not, can the employee perform the existing job in a modified or rebundled form? And can the employee perform another job in its existing form? So that's looking at, shifting workers from facilities or between positions sometimes happens. And thinking in the COVID-19 context, if you have a worker who is immunocompromised, who would normally be working perhaps where they're more public facing, looking at, is there something they can do in the back where they're not coming into contact with the public as much? Can an employee perform another job in a modified form? So looking at if there are other tasks that workers could do, would this worker be able to just switch to that job, or would they need an accommodation within that? So perhaps they would need a support built or some sort of platform or some other form of accommodation, whether it's physical or based on changing their schedule around or something of that sort. So that's sort of the questions that you need to ask to get to the point of understanding what could reasonably be offered. And so the sort of limits of that is that the employer doesn't have to create a new job where one didn't previously exist. They don't need to bundle together duties that wouldn't be productive for the company. And they may be, however, required to bundle some duties together that wouldn't ordinarily be bundled together in order to allow the worker to have that modified, accommodated work. It is important to remember that accommodation is a shared responsibility. So the employer has the prime obligation to accommodate, but the employee also has a role to play in participating in their own accommodation. So they can't, not have that conversation with the employer. If a doctor's note is requested and they're not forthcoming with that, that could result in, in non-culpable dismissal or being dismissed for, not for, I guess, for frustrating the employment contract, essentially. So they do need to participate. And if if an accommodation is offered that's reasonable, even if it's not the employee's preferred accommodation or the one they would most like, they are required to take a reasonable accommodation. So, and where a union is involved, a union is required to participate in the accommodation process, and they can't refuse a reasonable offer of accommodation. And that's like, as I previously discussed with the collective agreement, if they're looking to change a shift schedule to allow a worker with a protected characteristic to have that accommodated shift schedule, the union can't unreasonably deny that. And so this is just a little reminder that you have to always do an individualized assessment to understand if you have a blueberry muffin, a chocolate chip muffin, or a chihuahua. So we'll move right along to discuss briefly the Occupational Health and Safety Act and the right to a safe workplace. So everyone has the right to a safe workplace, and everyone has obligations to ensure a safe workplace under the Occupational Health and Safety Act. And in Nova Scotia, this includes, we also have occupational health and safety regulations and violence in the workplace regulations. What we don't have, what some other jurisdictions have, is a requirement for a anti-harassment and anti-bullying, or put another way, a respectful workplace requirements coming from the Occupational Health and Safety Act. There are other provinces, New Brunswick, Newfoundland, Ontario, Saskatchewan, and I believe British Columbia all have legislation that does require taking occupational health and safety to that next level to include harassment and bullying. So this may be relevant for workers as they go back to work following the pandemic. And it's relevant in any other time, but what I've found is that individual workers are not necessarily aware of their rights and obligations, especially their rights flowing from an Occupational Health and Safety Act. So in industries such as the service industry or small private businesses, there are still rights for workers under the Occupational Health and Safety Act. So if you believe that there is a condition within your workplace that is unsafe, you do have the right to refuse work that is unsafe. So there's some parameters and limitations to that. For starters, it has to be based on a reasonable belief that the work is unsafe. So with the example of COVID-19, if your employer, for example, hasn't taken what are considered to be the proper precautions that are putting up, sufficient signage or social distance markers, or if there are conditions that you consider are creating a condition that may make it more likely to contract the virus by working there, that can be raised with your employer. And that is the first step, is to raise that with your immediate supervisor, or if your workplace has one, an occupational health and safety representative, which would sometimes be called a joint occupational health and safety representative. So the first step is to raise it to that level and let them know that this is a safety concern that you're raising and that you don't want to work in that area. And once that's raised, the onus shifts to the employer to investigate. And if there is a problem, if there's a safety concern, to remedy it, or to determine that there's not a safety risk and to let you know and to ask you to come back to work. And once it's been investigated or remedied, you are expected to go back to work. But until it is, you can't be punished for raising a concern under this act. And you can't, for example, your employer can't dock your pay or fire you for raising legitimate safety concerns under this act. If it's not remedied to your satisfaction, the next step would be to take that concern to the Department of Labor and Advanced Education and speak to an officer there, a commissioner, and explain the situation to them, and they are mandated then to look into it. So there's sort of very specific steps you have to take. Other components of this that are important to understand, that if your employer, you know, accepts that you don't want to work in an area that's unsafe and starts to look into it, they can, rather than have you off work and not paying you, they can offer you modified work, which you would be obligated to do. Or they could offer that work that you've refused to another employee who they would need to make aware that this work had been refused by another employee, but they can have another worker do the work that you refuse to do, and that is, they are allowed to do that under the Act. And those are the points, the essential points I wanted to raise on the Occupational Health and Safety Act. And the only other caveat I'd like to flesh out there is the idea that there's sort of this gray area where an employer has a duty to accommodate someone who has, for example, been diagnosed with anxiety. They also have an obligation to, or a duty to, accommodate someone who has symptoms of COVID-19 or may likely have been in contact with someone who had COVID-19, or someone who's immunocompromised within the new conditions in our workplaces due to COVID-19. But if you are just afraid that you might catch COVID-19 and your employer has taken all of the proper safety precautions, there's no duty to accommodate, you know, having anxiety or because you're afraid of catching the coronavirus. So there's this, I anticipate a potential question there, but it's, I guess simply put, your employer is not required to accommodate your fear of catching COVID-19. It needs to be more than a fear. And I know that a lot of us in the last few months have been feeling fear and anxiety around what is going on, but there are these sort of distinctions to be made within these ideas. So I'm coming to the end. I've just put a slide here with some resources that talk more about some of the things I've discussed here with you. And I've also put my contact information at the end, and I will make these slides available through Caitlin and Catherine. And that is all that I came to share with you. If anyone has any questions, I'm happy to take them.
All right, so actually Catherine does have one question. So I feel there are very blurred lines in Nova Scotia around safe return to work, and the government is more or less letting workplaces build their own guidelines for return to work. How would this affect individuals with disabilities, would you say?
Well, I think that you may be, I don't want to criticize the government, but I think there are perhaps clearer guidelines and resources in other jurisdictions, and maybe in the next few days or so we'll see more resources roll out for people. But I think the Halifax Chamber of Commerce has good resources, and the Workers' Compensation Board of Nova Scotia has good resources for employers. But I think, as with anything that has the potential to negatively impact employees or workplaces, then people with disabilities who oftentimes have a difficult time making their needs understood stand to be more negatively impacted. So I think having presentations like this, having awareness weeks like this are good steps to take in trying to A, make employees aware of what their rights are, and B, making employers understand what their obligations are. But if employees have those concerns, I think, you know, do review what the occupational health and safety standards are and guidelines are, and what your steps are in remedying that. I have put a link here in my resources slide of how to file a labor standards complaint, and that has the information in there about the Occupational Health and Safety Act. Does that answer your question?
Yes, it does. Awesome. So actually, that was the one question that we had. I just double checked on Facebook Live, but I want to thank you, Andrea, for coming on today and presenting on the duty to accommodate and you know, the occupational health and safety. It was a great presentation. And so I want to thank you for joining us.
My pleasure. I really appreciate that you've put this on, and happy Accessibility Week to everyone. And I do believe this video will be, it's recorded, so it's available, and people can contact me with questions if they're watching it after it's gone live.
Yeah, definitely. All right, so thank you everyone for joining, and we have our last webinar of the day at 4 p.m. So if you're joining us then we will see you at that time.